Well, to my honourable friend for giving way, I don't think he has fully established the inviolability of the individual's rights. That he has stated it, but I think not established it.
This is a fundamental philosophical debate which the honourable member for North East Somerset has raised with enormous eloquence, and the answer to the question is that one cannot establish the existence of inviolable rights unless one accepts two further principles: the equality of humans, the notion that myself, Mr. Deputy Speaker, the honourable member for North East Somerset, and indeed somebody that we have never encountered at the other end of the Congo, is in all important respects equal in dignity and rights. This is an insight of logic, an insight of human consciousness, a basic commitment to the notion that although we may feel that we are special, although we may be tempted to feel that we are the only people that exist, as we become adults, we acknowledge that other people are themselves independent moral actors who possess exactly the same dignity. The inviolability, the rights of the human being, which the honourable member has raised, is derived from that notion of equality and dignity. What it says...
Called to my honourable friend once again, and for the record, I think the Deputy Speaker is so many leagues above me that I'm not sure that my honourable friend's right. Except, if one takes his point, the equality of humanity, the equality before God, which I believe is a matter of faith, that does not mean that rights are always applied equally. And even in this bill, on the right to life, that most essential right, you see it qualified in the case of self-defence. So rights immediately become relative.
Rights are indeed qualified. This does not mean rights are relative. This is an important distinction. The subclause which the honourable member has referred to in the bill indeed establishes a right, but says that under certain specific circumstances that right may be qualified or overruled. That is not a statement that the right is relative. It's not a statement that the right to life contained in the European Convention of Human Rights is purely relative. It's not a statement that below the threshold of the qualification, and I come back to the threshold of the qualification, below the threshold of the qualification, in other words, the specific circumstances in which that right may be suspended, below the threshold of that qualification, and this is what makes rights quite different from any other form of moral law, below the threshold of that qualification, your possession of a right is not relative to the costs or benefits of upholding it in any particular case. On the question of the right to life, your right to life may be suspended at a certain threshold. Those thresholds described in the European Convention include thresholds on civil disorder. They include thresholds relating to military law. But below that threshold, your right to life cannot simply be looked at in terms of the costs or benefits in upholding it in any particular case. In other words, I give way.
To my honourable friend once again, but this right is so clearly absolute because if you think of the old Riot Act, which provided for the militia to start shooting, that was a decision at that time to maintain order required immediate use of fatal force. That is no longer thought to be appropriate. It is therefore a relative judgment relating to the balances of the individual and the collective.
Mr. Deputy Speaker, I think we need to be very, very clear what we mean by relative. There is a notion of relative, which the honourable member for North East Somerset is rehearsing, which is simply to say that rights and moral values evolve in a historical context. It is simply a question of historical fact, as the honourable member says, that different cultures at different times have taken different moral positions. Aristotle, along with his other great observations, of course, believes that women and slaves lacked souls. Today we realise not simply that it's relative, not simply that he thinks one thing and we think another, but that he is wrong. He is wrong because moral language is implicitly not relative. Moral language is, in its very structure, absolute. Moral language does not say, I don't happen to like you killing someone, but if you want to kill someone, that's up to you. In other words, moral language doesn't say that killing someone is like you liking chocolate ice cream and myself liking strawberry ice cream. Moral language says it is wrong. It ought not to be done. Moral language is about questions of ought, not questions of is.
But, Mr. Deputy Speaker, it goes immediately on from saying it ought not to be done to add except in the certain circumstances.
Rory, Stewart.
Try again. The central point to be made is the notion of moral obligation, the notion of what ought or ought not to be done, relies on two conflicting principles which connect at the moment of the threshold. Those two conflicting principles are the notion of the inviolability and dignity of the human being on the one hand, and on the other hand, a consequentialist or utilitarian argument of the greatest happiness of the greatest number. Philosophically, the origins of these two types of argument are entirely distinct. One of them is a deontological argument. It simply states the dignity of the human being and their inviolability. The other is an instrumental argument. It's an argument based on consequences or results. Our legal system, and indeed our moral intuitions, combine these two, and the two meet at a point of threshold. This is what we mean by ought. What we mean is exactly what the Honourable Member for North East Somerset has said. The individual ought not to be treated like this, except in very extreme circumstances at a certain threshold, and below that threshold, the individual's possession of the rights is not a function of the costs or benefits of upholding it in any particular case. This is important because this is a distinction between a relative position which says, I can take your life whenever I feel like it on the basis of no moral argument and no logical position, and a separate position which says, Mr. Deputy Speaker, I may not take your life. There are certain extreme situations in which it could become legally permissible to do so, but I may not. The distinction between human rights and a relative position is a distinction on permissibility. It's a distinction on what may be done. Before the Honourable Member for North East Somerset intervenes again, just to be absolutely clear, the distinction is this. When I say, Mr. Deputy Speaker, that somebody has a right not to be tortured, I am saying they may not be tortured. I'm not saying they will not be tortured. There might be a horrible situation in which their government tortures them. The statement is a moral statement. It's not a prediction about the future. It's a statement about what we morally give permission to do. You may not be tortured. You may not be killed. It is then possible to state certain threshold circumstances in which our moral intuitions in terms of human rights shift to moral intuitions in terms of a consequentialist worldview, in which we say one might be killed for the benefit of a million. These are nice questions of moral philosophy. Usually they don't come up in our everyday life. Our everyday life is based on the dignity and inviolability of the human being regardless of circumstance.